Okay, so let's start. Okay, so I am Francie Monique Ayabalde for those who are not from COC. And hello. Can I speak Visaya, or there are students who can't understand vernacular? Do we have Tagalog here, or kasabot ba tatanan sa Bisaya, or do you want me to speak in English or Tagalog lang? Nabatay Tagalog dari CJ?
Wala po, ma'am. I think Bisaya tanan ni ma'am.
Okay,
Yes, ma'am.
much better. Okay, so let's start criminal justice system. So I have mentioned that we have table of specification. So here we have enumerate and explain 5 pillars of CJS as structure and as a process. We also need in the specification explain various CJS models and CJS philosophy and approaches. Discuss the relationship between the criminal, the criminal law, the victim, and the criminal justice. We need to elucidate components and functions of Philippine criminal justice system, discuss the linkages of the Philippine justice system. Sorry, can you mute yourselves? And differentiate the system of CJS in the differentiate the system of criminal justice in the Philippines compared to our barangay justice system. Okay. So as defined, we all know this, that criminal justice system is a machinery which the society uses in the prevention and control of crime. So it's the machinery. Why is it the machinery? Because there are several components of criminal justice system. That's why we call it a system, because it's a step, it's a procedure that we need to follow. We can't jump from one step to another. We can't just start with corrections. We need to start with law enforcement. We can't just start with court. No, that's why it's a system, because we need to, it's a process, it's a step by step, it's a procedure. It's a machinery because this is the system. The system is used to to prevent and control these crimes. It's a machinery because of the several institutions involved in the prevention and control of crime. It's just a machinery. Another one is because the main prevention and control of the behavior of human being is basically our laws. Without our law, no control. Without our law, no harmony between between persons and persons, or even state and persons. So that's why we need laws to prevent and control our behaviors, because if we don't have baseline, wala tayong baseline, then basically we can just do whatever we do, whatever we want to do. Yes, we have human rights, we have basic rights which the state cannot prevent, but still all of our rights basically are not absolute. No, it's not absolute, because we are living in society. We need to live with other people. So if you want that your right be absolute, you just want to live, you just want to whatever you do, then live in an island where anyone can't see you, or wala kay kauban wherever you live. So bottom line is our rights are not absolute. Even our constitutional rights are not absolute. Okay, remember that. By the way, I have not lectured for a long time, so if my ways are very fat, the way I explain is paspas kayo, no? Maybe some of you paspasan kayo sa ako or what. You can just unmute yourselves and say, "Ma'am, murag paspas kayo." So just caution me so I will know if I am too fast. Okay, I will try my best to slow down. Okay. So here, what's the relationship between crime and law, victim and criminal, and the criminal justice as a whole? So we know and we knew in our study that nulum crimen nola pena sinilihe, right? There is no crime if there is no law punishing such crime. So basically, if you look at it, there is crime because there is particular law saying or prohibiting this particular act. For example, I want to drive a motor vehicle, no? So basically, it's our right. We have the freedom, we have the liberty to do whatever we want. We want to drive vehicle, motorcycle, no? But because there is a law saying that you can't just drive without a license. So if you drive without a license, then that becomes a crime. So basically, our behavior was regulated. The crime is a product. If you will look at it in that definition, the crime is a product of law. Because if there is no law saying that that particular behavior is prohibited, or sorry, if particular behavior is a crime, then definitely that's not a crime. I'll give you an example. In part of Africa, in some part of Africa, rape is not a crime. In the Philippines, rape is a crime. But in that part of the world, rape is not a crime. So meaning they can just grab woman and do whatever they want, and that's not a crime. Why isn't it a crime, ma'am? Because basically in their country, there is no law saying that if you do lewd and sexual acts with women, then that's a crime. So again, let's go back to that. Law, a crime is actually a product of the law that we have created, that the state have created. Remember that the crime has two categories. We have mala inse, mala prohibita, or crimes from revised penal code, our public or municipal law. Remember that the revised penal code is considered to be our municipal law or a public law, compared to our mala prohibita or mala prohibitum special laws. Okay, so our special laws are considered to be laws of mala prohibitum, but not all of that, because there are certain special laws that are considered to be mala inse. Rape, for example, RA 8353. Before, rape is under crimes against chastity, right? Crimes against chastity. But by virtue of RA 8553, that's approved 1960s, if my recollection is still correct, 1960s, RA 8353, the crime of rape became now a crime against, became now a public crime. From crime against chastity, which is a private crime, it became now a crime against, it's a public crime, not a private crime. Why we need to differentiate that? Okay, we need to differentiate that the crime is a private and public, because by that, we will know who can file for this particular crime. So for example, before crimes against chastity or all the crimes against chastity, what are the crimes against chastity? What are these private crimes? So we have, before, I'll include rape. Before, we have rape, seduction, abduction, acts of lasciviousness, concubinage, and adultery. So those are the crimes against chastity under the revised penal code. But because of RAA 353, so rape now becomes crimes against persons under revised penal code and now considered as a public crime. So why we need to distinguish that? Because in private crime, it's only the direct offended party can file for such crime. So for example, in acts of lasciviousness or in abduction, seduction. In seduction, for example, it's only the direct offended party, the woman. No, it's not, sorry, the term. It's not the woman, but it's basically a child, because in seduction, the age of the person is more than 12, below 18. So that's for the victims of seduction. So general rule, it's only that child who can file for the crime of seduction against the perpetrator as a general rule. Okay, why you say, ma'am, that general rule? Because your rules of court criminal procedure provides that in cases of seduction, abduction, acts of lasciviousness, in cases of those crimes, when the direct offended party cannot file by reason of trauma, by reason of death, by reason of, no, sorry, trauma, insanity, um, because of such crime of seduction, abduction, acts of lasciviousness, di na siya makastorya, he can't do because of the trauma and so on. Then the grandparents, the parents, or even the older brother and sister with at least 18 years of age can file for the crime of seduction against the person. That's as the exception to the general rule that only the direct offended party can file. So if there's no grandma, if there's no parents, if there's no brothers and sisters of at least 18 years old, then it's the state who can file. Okay, the state now has the personality to file a crime against the perpetrator. That's under our doctrine of parens patriae. Okay, so that's why we need to distinguish private and public crime, because with that we will know who can file. Because with this private crime, even if you witness the crime, you witness that this person was seduced, you witness that this person was hikap-hikap siya for acts of lasciviousness, okay? Or rape, for example, for crimes against person. Even we witness, even we have personal knowledge that these crimes has been committing or had or is committed, we can't just file for a case in behalf of the victim or in behalf of the person who was seduced or whatever, because it's a private crime. Unlike in unlike because it's a private crime, unlike in public crimes, okay, like rape, like murder, like homicide, like physical injury, like a rebellion, no, insurrection or sedition or other forms of crimes under the revised penal code or even special laws. If it is considered as public crime, then basically any person who have personal knowledge can file. I'll give you an example. Trafficking in persons. Trafficking in persons was it was really provided in the provisions of the special law that it is any person who has personal knowledge of the crime can file for the case. So that's why it's very important that we need to know if the crime is a private and if it's public. Now let's go back to sorry, let's go back to the thing I've said, that nullum crimen nolla pena sinilihe. There is no crime if there is no law punishing such crime. Okay. However, if you will look at it, our fundamental law of the land, so Title 2, diba, it's considered to be fundamental law of the crimes against fundamental law of the land. Why is it called crime against fundamental law of the land? Because your Title 2 is crimes against the Constitution, our fundamental law of the land. Now, if you look at it, there are certain provisions in the 1987 Constitution that cannot function or is not, though it is written there, okay, is not in per se enforceable law. Okay. For example, the 1987 Constitution provides that we have the right for equal social and economic we have the right in social and economic functions in this aspects in the society. So we have the equal right for economy. So dapat pantay-pantay ta. We have equal right in economy. So when you say economy, in business, in for profit and so on. So that's provided in the 1987 Constitution. However, it's not per se enforceable because there are certain provisions in the 1987 Constitution that we need generally, we need laws, we need a special law for the provision of the Constitution to be effective. Another, dynasty. The political dynasty is abhorred in the 1987 Constitution. It says there that there should no political dynasty. But what's happening in the society now? We have political dynasty because that provision of the law per se is not enforceable because we need special laws for that. However, there are also certain provisions that even if we don't have special law are effective per se. In fact, we can sue the person because of this provision in the 1987 Constitution. So for example, you have the right to life, liberty, and property and due process of law. Even if we don't have a special law providing, no, if you have been studying for how many years, but you have not seen a special law or whatever there that provides that we have due process and so on, because there's no need for a special law for that. So we have the right to life, liberty, and property. We don't need laws for that. In fact, even if we don't have murder or homicide provision in the revised penal code, your right to life still enforceable. You can still prosecute the person by virtue of this Article 3 Bill of Rights of the 1987 Constitution. So if you look at that, that's a side note in our nullum crimen nulla poena sinilhe, no? Okay. So mala in se and mala prohibita. So generally, mala in se are those crimes under your revised penal code. And mala prohibita or malum prohibita generally are those crimes under the special laws. Okay, so mala in se, in special laws, it is wrongful in nature, immoral in nature, while in mala prohibita, it's not really wrongful in nature. It's just wrong because the law provides for it. That's why mala prohibita is an characteristic of a special law. But again, I've mentioned not all, because there are certain provisions that are considered to be mala in se even if special law siya. Okay, another one, if it's mala in se, you can use good faith as a defense. For example, in your murder or in your homicide, no? If you can say, I did not murder him intentionally, it's just a defense, no? I defended myself. Or, wala na ko tuyo it's not my deliberate intention. Pag lingi na ko, wala ko kabantay nga naman siya din ha, and then whatever you do, nasugatan siya or saba na natugsok nimo or whatever. So in short, in mala in se, good faith can be a defense. However, in malum prohibitum, good faith cannot be used as a defense. So for example, you say, oy, wako kabalo man di ay nga kaniman ding drugs is a crime. I don't know that. You cannot use that as a defense. So another one, in mala in se, you're justifying your jimaa, diba? You're modifying circumstances. You're justifying, exempting, mitigating, aggravating, and alternative. Your jimaa, you're modifying circumstances. You can use that in mala in se. Meaning, if you have if you kill the person as a defense, you can use that in mala in se, but not in mala prohibitum or in special crime. You have mitigating circumstances like passion or obfuscation. That's example of your mitigating circumstance. You can use that in your mala in se, but you cannot use that in special law. Okay. However, there are exceptions. I hope you can catch this. There are exceptions. Whenever the special law uses the nomenclature or uses the penalties provided in the revised penal code. So what do you mean by this? So for example, remember the penalties of our revised penal code? We have reclusion perpetua, reclusion temporal, prison mayor, prison correctional, down to arresto menor. That's the penalty in our mala inse. If that penalty is used in special law, then it is as if all the modifying circumstance and all the others we can use in mala inse can be used in malum prohibitum. So if the penalty of the law, the penalty of the special law provides that reclusion perpetua or reclusion temporal or arresto menor, arresto mayor, if those things are used in special law, then we can use good faith as a defense. We can use good faith as a defense in a special law. So that's the implication. That's why, diba, if you've been reading if you've been reading a special law, there's when you read a penalty where nag-ingon reclusion perpetua or prison correctional. So that's what I am saying, na nomenclature used by special law, penalty of the RPC used in special law, then basically we can use good faith, we can use justifying circumstance, we can use aggravating, we can use alternative in the special law. But general rule, we cannot. As an exception, if used by the special law nomenclature of the revised penal code, then we can use those in special law. Are we still catching up? Di man gud ta mo makita. I can see your reaction, or I can check if you have understood. Kasabot ba ta sa ako? Do you catch it? Nasabtan ba ninyo?
Yes, ma'am.
Ma'am.
Ha?
Yes, ma'am.
Nasabtan
Yes,
ba?
ma'am. Yes, ma'am.
I hope so ba? Kayo naglahi gid ning Zoom, no? It's my first time for a long time to discuss in a Zoom. Okay, anyway, so I hope nakatch na to, ha? So that's crime. Now let's go to law. But basically what I have discussed is implications na also of the crime and law. So again, for law, we have, remember that we have felony and offense, right? So when you say felony, that's a law, that's a crime punished by the revised penal code. And when you say offense, that's a crime punished by the special law. But please beware, under your juvenile justice system, under your RA 9344, now under RA 9344, the juvenile justice system used offense as different different definition. Because if you look at jurisprudence and if you look at criminal justice system, here we use the word offense as a crime, again, punished by the special law. And when we say felony, crimes punished by the revised penal code. However, under RA 9344, your offense is defined as a crime punished by both revised penal code and your special law. So be careful before you answer the question. Check what subject is that. Okay, if crimsok na, check if what's the tone of the question. Because if it's more of juvenile, then the offense word used there is a punishable under revised penal code and under special law. So that's for your RA juvenile justice system. That's why if you have remembered, because I have remembered, I've been telling you that when you study, do not jump from one topic to topic. You need to check first, because there are certain terms that have there are terms repeated in different subjects but of different application and of different meaning. Diba? One of that na is the word offense. Another one is the word recidivist. Remember in your Leia, the word recidivist is defined differently compared to your jurisprudence and your CJS, where recidivist is a person who committed a crime twice under the revised penal code. Remember that? So if a person committed the crime of rape first, nakalaya, already served the sentence, year after committed the crime of murder, is a person recidivist? Yes, he's a recidivist, because the two crimes are committed under the same title of the revised penal code. So please do check your reiteration, your habitual delinquents, your quasi recidivist definition. So I leave it that up to you. Okay. So in law, remember we have fundamental law of the land, our 1987 Constitution. As I have mentioned, not all provisions are enforceable as a crime because we need a special law for that. We need a special law for it to be considered as a prohibition for us to do. Second, we have municipal or we have public law, our revised penal code. So remember, ginabalik-balik na ko, it's considered municipal and a public law. Municipal because of our three characteristics of the revised penal code. Remember, we have, or these characteristics can even be applicable to our special law. So these characteristics are of general, except if the special law provides for its exception. So we have three characteristics of criminal law. We have generality, territoriality, and prospectivity. So remember that. So pag generality, it pertains to who can be punished under our revised penal code. When you say territory, where? Okay. When you say prospectivity, we answer the question when. So if generality, who? Any person who live or sojourn in the Philippine territory can be punishable under our revised penal code, regardless of what race you have. No, if you committed a crime under the revised penal code, then if you live or sojourn in the Philippine territory, then you can be covered in our laws. Of course, you need to check the exemption to that, Article 2 of your revised penal code. Second to that is our territoriality, where if you committed a crime, I'll retract that. The exception, Article 2, is under territoriality, right? So Article 2, when you commit a crime anywhere in the Philippines, okay, provided that it is within our Philippine territory, then you can be prosecuted of the crime, with the exception of Article 2 of your revised penal code. So even if you are in foreign country, but you committed a crime on board a ship or airship, remember that the very requirement of our airship or ship should be Philippine registered. So if the ship or airship is not Philippine registered, even if the victim or the perpetrator is a Filipino, then we cannot prosecute the person, the victim, the suspect in our country because that's outside our jurisdiction already. So remember that. Also, any crimes against national security, even if committed outside the Philippines, that still be punishable under our revised penal code. Okay. The third one is we have the prospectivity, but remember that in our prospectivity, there are exceptions to that, no? So prospectivity, if the crime was created today, effective today, on this day, only those crimes committed on this day forward can be punished under the law, with the exception of if the crime is favorable to the accused. Remember, if the law is favorable to the accused, then you can use the law in favor of the accused. However, with the exceptions to the exception that the person should not be a habitual delinquent. Remember? Habitual delinquent. So if, for example, si Mario, as an example, si Robin Padilla. No? Robin Padilla was prosecuted of the crime of illegal possession of the firearm. So at that time, it was PD na law pa of the firearm. And then later on, the new law of firearm was created where it lowers down the penalty for those who illegally possess the firearm. So now, since the new law of firearm is favorable to Robin Padilla, then the law of then that law is applicable to Robin Padilla. However, if at that time Robin Padilla was considered as habitual delinquent, even if the law is favorable to him, then that law cannot be applicable to him because that's the exception to the exception. I know you know that. I hope you remember that. So that's basic, no? So yeah, so other laws like procedural law and other laws that don't vest right to such person can also be applied retroactively. Okay. Example to that is our procedural law, except if the procedural law prejudices prejudices the person, then that cannot be applied retroactively. So that's the relationship between crime and law. Now let's go to the relationship between victim and criminal. So for this relationship of victim and criminal, remember our theories, no, like victimology theory, where it says there that the victim has a part in the commission of the crime because of the routine of the victim, no, our routine, because of the routine of the victim, then natimaan na siya sa perpetrator that she goes here at this time every day for the whole month or for how many months, then makita na sa perpetrator your routine, your pattern, then with that, you give an opportunity for the criminal, for the perpetrator to do something to you. So that's under our theories. So for the relationship of victim and criminal, you may refer to our theories. Another one for this relationship of victim and criminal is our barangay justice system that we will discuss later, and the difference between criminal justice system and our barangay justice system. So why I say there's a relationship between victim and criminal, because in the barangay justice system, we don't prosecute literally our criminal, but we make sure that we arrive into a settlement, into an agreement for this victim and criminal. For this two persons who have disagreement, arrive to a particular settlement. We don't really call the person criminal unless the person has been guilty beyond reasonable doubt. So remember that. Okay, so we have here, as mentioned, when in the pillars of criminal justice system, if it's still in the law enforcement pillar or law enforcement stage, we call the person suspect or persons of interest. No, so we have new name now. Instead of suspect, we have persons of interest. But if we will compare the suspect and persons of interest can be anyone. Can be a witness, it could be a person, your silingan, it could be your classmate you have met before the crime is committed. So these are persons of interest. But when we narrow down from those persons and then we omit one, kanino, then if we narrow down to one, then that person of interest becomes now the suspect of the crime. And then second pillar, we have prosecution. From suspect, we call the person respondent. And then when the person reached the court, then we call him accused. And when we reach the correction stage or pillar, then we call the person convicted, or we have new term, person deprived of liberty. And then in community, ex-convict or balikbayan. So you need to remember these terms. You need to remember, you need to check where these terms are used so you can answer the questions effectively. So if the word used is respondent, so you're seeing na, okay, napa na siya sa prosecution under filing of complaint, and the prosecutor will file information yet. No, so you need to check the terms. Okay, so let's go to functional components of criminal justice system. So the police, they are considered the law enforcement officers. It's the police really because among the law enforcement officers, generally police are the maneuvering pillar. So they front line to our criminal justice system. Except if the jurisdiction is under NBI, then it's the NBI. But if not, then generally it's our Philippine National Police. It's the PNP. Okay, so here the purpose of the police is to gather evidence and possibly arrest the suspect. Arrest the suspect if the crime was committed warrantless, we committed in flagrante delicto or caught in the act, or it was committed during the hot pursuit or with personal knowledge, or when the person is an escapee. In short, police arrests the suspect via warrantless arrest. So that's what we mean by arresting the suspect in this police stage. But generally, if it's not warrantless, if it's not committed under warrantless arrest, then the purpose of the police is just to gather evidence to help the prosecutor establish the guilt of the person in court. So that's the job of our police, gather evidence. That's why, sorry, I'll just like to side note this. That's why if all of you will decide to join the Philippine National Police, if you will already pass the board and there's a quota, I hope that you will enrich your knowledge of the law. That's the fundamental requisite of a PNP, supposedly, that you should have rich, fertile knowledge of our laws. Because since you're the front line, I'll tell you, there are many bright lawyers who will just ego you with technicality, especially the chain of custody. And if you don't have knowledge of the law, or if your knowledge of the law is very shallow, then basically we can say that the dismissal of the case is with our fault. It's the fault of the police. So I hope that if you will, I'm saying, disclaimer, I'm not saying that all of the dismissal of the case is the fault of the police, but the contributory. Because during the cross-examination, during the court, police are the primary witnesses because you will be asked what happened. And if the lawyer will just makita siya loophole in your for example, gathering of evidence or even in due process, then that can result to dismissal of the case. So I hope that whenever you decide, then you will enrich your knowledge of the law. Next up is the prosecutor or the prosecution pillar. Okay, the job is to evaluate all the evidence that the police have gathered. So ang prosecutor tig-filter, no? If those evidence that you have gathered are in his or her opinion can be used as evidence in court, and decide whether it is sufficient to warrant the filing of the charges against the alleged violator. So remember, the prosecutor will check during the preliminary investigation if there is really probable cause to believe that this person has committed a crime and there's a probable cause for the prosecutor to file an information before the court. Okay? That's job of the prosecutor. Defense attorney, of course, that's the job of the defense attorney to help and to protect the rights and interests of the accused. Okay, remember, pag prosecutor, victim yan. So the prosecutor is the one who protects the interests and accused of the victim, and the defense attorney is the one who protects the interests of the accused. Why do I say interests? because remember that the lawyer is actually not there to cover the crime that has been committed. It's not there to lie. The lawyer is not there para mamutbot na, "Oy, my client is not the one who committed the crime." No, that's not the job of the lawyer. But the job of the defense attorney is for him to protect and make sure that you have your day in court, and that the victim is not that the accused is not prejudiced and has served or given his rights as provided in the law. So that's the purpose of your defense attorney. And the judge during the trial, the arbitrator in the court, who ensures that the defense and prosecution adhere to the legal requirements for the introduction of evidence, offering of evidence, examination, and cross-examination of the witness. I believe Attorney Sarah Bihega already discussed with you evidence, no? So I hope that you have checked that out. We have very substantial amendment of your evidence. So if you have not read yet the amendment, substantial amendment of your revised of your evidence, please do so. Okay. Because, for example, we have original document rule now instead of best evidence rule before. We don't have best evidence rule. The term now is not best evidence rule, but it's original document rule already. So check that out. I believe that your examiner, Chairman Gabao will already use the new sets of the new rules on evidence and also some part of the new rules of court. Okay, so next, after the judge to check if the evidence are there and the evidence are good to go, and then the judge will render decision. Okay. And the probation officer, we have here probation officer if the crime is probationable and if the petitioner is qualified for probation. So remember those qualifications of your probation. So that will be discussed under your non-institutional corrections. But just a little background also on probation. Remember that the rule on probation is that the moment you appeal the case, for example, Mario has been convicted of a crime where the penalty is 6 years, right? So 6 years is probationable because it's not more than 6 years, provided that the petitioner is qualified with all the qualifications of the petitioner, then the court may grant. But what if this is the case? But before that, remember that the moment you appeal 6 years, for example, in MTC, you appeal to RTC because you believe that you really are innocent, and then upon arrival at the RTC, naging 7 years yung decision ng RTC instead of 6 years. So remember, you cannot say, "Oh, I withdraw my appeal and go back to the 6 years so I can file for probation." No, because your appeal is a waiver for you to file for probation. However, if 6 years lang yung penalty mo, you file for probation. However, hindi gigrant the judge disallowed you to be granted of probation. So denied ang imong petition for probation, but you really believe that you should be granted probation, you have all the qualifications and etc. Remember that under your probation law as amended, it says there that you cannot appeal the decision of the judge to grant probation. Remember? So if I'm the judge, gingon ako nga, "Oh, you are not allowed to I will deny your petition for probation." You cannot appeal my decision of denial. So the accused cannot say, "Judge, I would like to appeal your decision of denying my probation to the Court of Appeals or to the RTC." No, you cannot do that. There's no remedy like that where you can file for an appeal on the decision of the judge denying your probation. However, okay, it's not na wala nag-remedy ang petitioner, because jurisprudence provides that if you believe that you really have the qualification nga dapat gigrantan unta ka sa korte, but I don't know bakit wala ka gigranti sa korte, you can file for certiorari or certiorari. That's allowed by jurisprudence. There was a jurisprudence where there's a case where the person filed for probation, denied, nisaka sa Court of Appeals, approve ang decision sa kanang RTC where there's no grave abuse of discretion resulting to lack of jurisdiction. So certiorari, di ba? Sige tagdagmaan ng certiorari. Ano ang certiorari? It's a remedy, no? It's not an appeal. Appeal is different from certiorari. If you look at it in layman's term, not legally, mura na gapon siya appeal because isaka nimo sa taas, but the remedy is different. Though isaka nimo sa taas na court, but the purpose of certiorari is to check if the judge abused his discretion in not granting you the remedy, in not granting you the probation, for example. So the Supreme Court says, yes, the lower court is wrong in denying the appeal for probation because kaning petitioner is qualified with all of these and the crime is probationable. So in short, yes, there is no appeal as a remedy, but we can file for certiorari. Okay, so that's for your probation. Prison system. So prison system receives the defendant if convicted and sentenced and keep them until parole is granted or have completed sentence. So remember the difference between your probation and parole. No, who can grant? By the way, question. Para di na lang sad ako perminti magsorya diri. I've been talking for almost an hour. Okay, I hope di pa mo naboringan or pa mo katulog diha. Question. If the parolee, I will call somebody, no judgment. If the parolee, okay, committed violations in his or her conditions of parole, question, who shall order his or her arrest? Any volunteer? Kinsay mag-order sa iyang arrest?
The court judge,
No
ma'am.
volunteer.
Trial court, ma'am, or trial judge.
Sorry, who's speaking? Pisa ni?
Tienza, ma'am.
Atienza, okay.
The
Atienza,
trial court, ma'am, or the trial judge?
Before I will answer that, my question back to you is, question, is the court has still jurisdiction over the parolee?
Yes, ma'am.
Remember that, what's the status of a parolee, di ay? Atienza? What's the status of a parolee? Aha naman ang parolee. Is the parolee had served sentence, minimum of his sentence, and then he was granted parole? Di ba, sakto ko? I am right, Atienza, right?
Yes, ma'am.
Yes. So question, is the court has still jurisdiction?
Ay, wala na, ma'am.
Wala na. So question, who can file for, who can issue an arrest order?
Parole officer.
The parole officer na, ma'am.
Kisa na nagsorya? Sorry, choppy. Or ako ba internet connection? Who shall order the arrest? Remember, pillars of criminal justice system, law enforcement and prosecution pillar are all under what branch of the government? Atienza? Law enforcement and prosecution, what branch of the government? How many branches of the government do we have?
DILG.
3, ma'am.
How many
Under
branches
the
of the government?
executive order sa under, ma'am.
Executive order? Ano sa executive order, Atienza?
Oh, executive department, ma'am, sorry.
Executive branch, okay.
Branch.
So your law enforcement and prosecution are all under executive branch, right? So law enforcement, for example, police under DILG. DILG is under the office of the president because that's an alter ego. Prosecution, that's under Department of Justice. And DOJ, that's under the office of the president. So executive branch ning duha. How about corrections? What branch? What branch, Atienza? Sige, di na si Atienza kay masiguro sinala ko na si Atienza. Manganawag ko or any volunteer. What branch? Ang court, what branch of the government? Ay naghan man day ug kanang nagkuan diri. Okay, what branch?
Judiciary, ma'am.
Judiciary. How about your corrections? What branch?
Executive, ma'am.
Corrections. Executive. Why executive? Because your bureau, for example, your Bureau of Corrections under DOJ. So that's executive, right? Sakto. Now, your parolee is already under your corrections pillar. So in short, judiciary has no jurisdiction over the parolee already. Why? Remember the independence principle of our three branches of the government? The executive cannot encroach to the judiciary for his job. The president cannot just say, "Oy, convict ng kuan diha." No, he cannot say that because these three are independent bodies. Now, the parolee is already under corrections pillar, under executive branch. In short, you cannot do lateral order. The judge cannot order the arrest of the parolee because the parolee is not already under his jurisdiction. So question, who will now order the arrest? That's why there was a question. I'm not sure what board is that, but there was a question. Can the parole officer arrest the parolee? The answer is yes. Because the parolee is already under his or her jurisdiction. But question, who shall order the arrest? It's who granted the parole? Who granted the parole?
Board pardon and parole.
Of course. So the one who grants has also the authority to decline and to withdraw his grant, and also has the power to order the arrest of the parolee. So it's Board of Pardons and Parole. Remember, please do away with your thinking na pag order of arrest gani always the court. No, it's not. For example, madto kag court, madto ka og airport, wa kay passport, magagandagan ka didto. Manawag pa lugar tag na police kay kamoy na authority to arrest. No, the immigration officer can arrest you. But take note that that's different on the case of a probationer, because now if the probationer violated certain mandatory provisions of the probation. Mandatory, for example, is you need to report at least once in a month, di ba? That's mandatory. At least once in a month, you need to report. Question, if I will not report, I will abscond. Question, who shall order my arrest?
Court.
Court. Why court?
Court ang nag-grant sa probation.
Other than that, court granted the probation. But remember, if you look at it, no, yes, the court granted the probation. So what happened to the sentence? What happened to the sentence of the probationer?
Hindi na rin nagkaon ng kami. Shit.
Yes, nakita ti kasig higda. Ganina ra na nag-on. Question, what happened to the sentence? What happened to the sentence? Back to zero?
Serve the
Revoke?
original.
Serve the
Serve the original.
original.
No, yes, that's
Serve
after that's after already the that's after the violation. But what I'm saying is, if the judge already granted the probation, what happened to the system? Yes, okay, it will be suspended, no? So if it will be suspended, who has still jurisdiction over the probationer? It's the court who has jurisdiction. That's why if the probationer violated certain provisions of the probation conditions, then the court has the power to order. Why? Because the court has still jurisdiction over the person. In fact, supervision and control your RA PD 968 as amended by your RA 1077 provides that the judge or the court has still the control and supervision over the probationer, even if it's the PPA who has the duty to check and supervise the probationer. Remember, the PPA, the Parole and Probation Administration, that's under your executive branch of the government. Even if the probationer is under his or her supervision, but it's still the court that has authority to order the arrest. In fact, it's not automatic na if you violated the provision, dili pwede nga i-arrest ka automatic. No, there should be a summary hearing. The probation law provides that there should be a summary hearing. Na the probationer should be invited to the court and explain why this and that, and then if the judge will really if after the evidence and narration, the judge determines that you really violated the provisions of your probation, the decision, your judgment shall be lifted, di ba? Kay suspended man to, it shall be lifted, and you will serve the original. Right? So that's the difference between probation and parole. So remember that it's the BPP and the court in case of probation, and BPP in case of parole. Okay. Next. So we have here two aspects of criminal justice system. I hope you will remember this and you will take a picture or what, because as I remember, this formal justice system came out in the board, and if mobalik, I hope, if mobalik ni nga pangutana. Okay, so formal justice system. So it's a traditional series of agencies that have been given the formal responsibility to control the crime. So it's an overt system. Okay, it's overt. It's traditional justice system where the control is mainly on the authorities, and they don't open the responsibility to the society. So there's a monolithic criminal justice system where it is really separate from community it serves. It has also a bureaucratic scheme. So thought of this formal justice system, it's an overt system, every day in operation, okay, where the sole authority to control and prevent the crime lies with the bureau, lies with the officers. So that's formal justice system. And there is a separation between the system and the community. While we have larger criminal justice system, okay, agencies and persons deal with issues related to crime prevention. So they excuse me, they see that the community is of help in the prevention of the crime, and that they recognize social control is part of the community, and not only crime control but maximum law observance. And they acknowledge the importance of community in the criminal justice system, unlike in the formal, unlike in this previous type of criminal justice system, the formal. Here in the larger, they believe that community is part of the criminal justice system. So let's proceed to katarungang pambarangay, and we will distinguish along the way the difference between katarungang pambarangay and this criminal justice system. Okay, so as provided under our local government code, RA 7160, so the procedures of katarungang pambarangay is reflected in this law, or is provided in this law. So the Lupong Tagapamayapa has 21 members, including the chairman, and the chairman has the discretion whether to go up to 20 members, or if gusto siya 10 to 11 or 12, that's fine, but the maximum will be 20. And secretary of Lupon is the barangay secretary, okay, under the Lupong Tagapamayapa. Remember that the Lupong Tagapamayapa is different from pangkat tagapagkasundo, pangkat tagapagsundo. So 3 members lang. The chairman and secretary shall be chosen among the members. Remember the general rule: after if there is a dispute, then the parties will go to the punong barangay, the chairman, the barangay captain, and if the barangay captain can't settle, then they will decide to create the pangkat, tagapagkasundo, 3 members, where the chairman and secretary shall be chosen among the members. So in these 3 members, excluding na ang chairman, since the chairman failed to settle the dispute of these parties, that's why they came up with this pangkat, and then the pangkat shall be chosen among the 10 to 20 members of the Lupon. And it's the parties that will choose. And if they can't, then we will, if they can't really choose, then we have raffle. They can raffle the members. And if upon raffle, they think that the members of the pangkat tagapagkasundo can be a prejudice to either of the party, then they can choose another one. So we have adjudication. Adjudication is defined as what we are doing in barangay justice system is we adjudicate. Okay, we adjudicate and we try to settle controversies and disputes. That's why may magpatawag, ay patawag nimo sa barangay or ahan ninyo ipatawag or whatever to settle the disputes. We call that adjudication. General as a general term, adjudication, where the power of the courts or quasi-judicial agencies to decide cases filed before them. Even the court has this alternative dispute resolution if the cases are within the jurisdiction of this mediation center. After the pre-trial, automatic that these parties shall be referred to mediation. Even the court, it's not only the barangay system has mediation process. So the mediation center will refer the parties to mediation or an adjudication, whatever the case may be. And if dili sila magkasundo, then that's the time that they will go to court. The same case in the barangay justice system, the parties will be settled in the barangay level, and if the parties can't settle in the barangay level, naagi siguro gahay ulo sa ilang duha, or they just want gid sila magka-settle, no? And then di sila magka-settle, then that's the time that the punong barangay with the help of the secretary will file for certificate to file action, CTA, and that's the time that the court will check no, the court will check if there's no need for preliminary investigation, then dito sa court. But if need of preliminary investigation or whatever, then ipaagi sa prosecution. Okay. I hope, I'm not sure if you can really appreciate this barangay justice system, but you know, I have appreciated this barangay justice system. Yeah, when I studied law, this is very helpful because trial, I say with much emphasis, stress, not only financially, but emotionally and physically. That's why, as much as possible, if you can settle in barangay level, then do so. Because if you will go to the court, you know, ko pila pa na ka years. Imagine I have attended an online hearing where because the lawyer is not there, the lawyer is sick, and because the witness is not there, the witness is sick, or any of the parties is sick, there's a postponement. Imagine na postpone today. The next trial hearing will be next year, 2022. Imagine that. Karon na postpone, diba? We should supposed to expect, okay, basig next month or next week or next. No, you cannot expect that. Next year pa na, and then the court really has already calendar of cases in the early 2022. The case was docketed and scheduled November 2022. Imagine. So that's why if you have, I hope you don't have any cases like this. I hope if that can be settled in barangay level, then do so. So we have amicable settlement. It's an agreement reached during mediation and conciliation proceedings. So if ang kaning duha ka parties nagkasinawat, okay, di na lang ta magkuan ani kani atong sabutan. And if they already have this agreement, specific agreement, the specific agreement is what we call arbitration award. Ilan ang i-review before they will deduce it to writing, para kay basig na pay mga sayop and etc. So we call that arbitration award. Arbitration award is the end result already before they will deduce it into writing. However, if after deducing it into writing, if the party still finds that in the writing there's still a violation, di ni mao nyo nasabutan, na ay fraud, violation, and intimidation, then the party can repudiate. The party can protest on the arbitration award, the written arbitration award. Okay, so we have process under Katarungan Pambarangay. So as I've mentioned, first, it's the lupon that will settle. We call it mediation under Katarungan Pambarangay. And if mediation is not effective, then we go to pangkat. Okay, so we call it conciliation. And arbitration, third party. But under the Katarungan Pambarangay, actually arbitration can happen in any of these stages. So arbitration, it's when third party, because it's not the members of the lupon that will settle, but it's the third party, maybe priest, maybe mayor, any person with you feel that you have moral ascendancy, then you can invite such person to arbitrate your dispute. So that's for arbitration, third party. Remember that you cannot bring lawyer in the Katarungan Pambarangay. Imagine the one who will mediate and conciliate, not a lawyer niya, magdadala kag lawyer. That's why you cannot bring, and in fact, and also in Katarungan Pambarangay, there's no trial there where you really bring lawyers. We don't check if evidence has been presented. We don't check if evidence are hearsay. No, that's why we call it mediation and conciliation. It's the barangay, okay? You will be heard out and then settle if things can be settled And if not, then go to the court. So these are cases not under the katarungang pambarangay. So first, where one party is the government. So if nagreklamo ka sa mayor, imong gireklamo ang mayor's office, you cannot bring that before the lupon. If one party is a public officer and your dispute is in relation to the performance of his duty, for example, public treasurer, niadto ka dito, nagreklamo ka, your tax is not properly, you are not properly assessed, no? In local barangay taxation, you are not properly assessed. You cannot go to the katarungang pambarangay. If involves real properties located in different cities, yuta, reklamo nimo ang muhon gi-transfer ang muhon, diba, to the other part. You cannot go to the barangay unless, remember, there's exception, if both parties agree to submit appropriate lupon. So these happen when the real properties are located in different cities and municipalities. But if you both agree that you settle your dispute in this municipality, lupon, aning municipality, then that's possible. Another one, complaint by or against corporations. Remember that the katarungang pambarangay only settles disputes of natural persons. Remember, we have two kinds of persons, natural and juridical persons. Juridical, we refer to company, corporations, but for individual, natural persons, us, no? So if either of the parties is a corporation or a juridical person, then you cannot file for you cannot ask the barangay to settle such dispute. Okay, so another parties who actually reside in barangays of different municipalities, except, okay, in cases where you submit yourselves to appropriate lupon, in the same case of real property, where you ask the particular lupon of the barangay to settle your dispute. Another offenses for which the law prescribes a maximum penalty of imprisonment exceeding 1 year. So if the penalty exceeds 1 year, that's not also under the jurisdiction of your katarungang pambarangay. So it's already under the jurisdiction of the court. And offenses where there's no private offended party, drugs, alcohol, violation of tobacco law, violation of alcohol law, and so on. There's no private offended party, then you cannot go to barangay to settle that. Okay, so we have, however, there are exceptions to the rule also that even if the jurisdiction is under the katarungang pambarangay, whatever you say, okay. I have here question, whatever you say in amicable settlement in barangay, dili na siya magamit. Yes, it cannot be used because, in fact, in katarungang pambarangay, you cannot bring evidence there nga oy, I would, punong barangay, I would like to present this evidence to you, no? We have, dili na ingon ana atong settlement sa barangay level because there's no trial. Even summary hearing, walay summary hearings sa kanang barangay level. What they do there is just to settle. Murag ato-ato ba, pang pamilya. Okay, unsa man imong gusto di ay. Sige, nakasala siya. Unsa man imong gusto. You cannot use whatever he or she says. You cannot use it before the court because that's confidential and privileged as well. Okay. I hope I have answered your question. Okay, so however, there are exceptions to the rule wherein even if the case is cognizable under the barangay justice system, but because of urgent legal action, example, the accused is already under custody or detention, then you can proceed to the court immediately without going to katarungang pambarangay. Another, even if the petitions are for habeas corpus, remember habeas corpus, you petition to present the body before the court. Remember the requisites for habeas corpus is if the person is detained illegally without legal grounds, you can file for habeas corpus. Okay, another actions with provisional remedies. When you say provisional remedies, these are remedies na not remedies which are provisional, meaning it's not final. You can file this remedy in the middle of the case, in the middle of the trial, but these are not final. So for example, you file for injunction case. Okay, you prevent this person to do such thing. You file that before the court. That's an example of provisional remedy. And if that is allowed by the court, it's only temporary. It doesn't mean that you cannot do such prohibited thing after this particular period of time. Okay. Actions which may be barred by the statutes of limitation. So if it will expire on such particular period, so that will not be catered under your katarungan pambarangay. Okay. Another disputes which the president may determine in the interest of justice. So if the president will say, okay, you go to the court or whatever tribunal, then that's another exceptions. Another is if it's under comprehensive agrarian reform law, that's also not covered. Labor, that's not covered. Actions to annul judgments, compromise. Okay, so it's also not under the jurisdiction of the barangay justice system. Labor disputes, why I say or why is it provided? Because the labor dispute is under the jurisdiction of your dole. So if any reasonable doubt that the accused committed the crime, he has to be acquitted. The statement is true. Yes, it is true. So even if there's only an insignia of doubt, no, minute doubt that the person did not commit the crime, the person shall be acquitted. Okay. So as my professor said, he said, proof beyond reasonable doubt. It's not an absolute. It's not an absolute judgment really that he or she did not commit the crime, but proof beyond reasonable doubt is when you decide a case where no inch of conscience and no inch of immorality murag mabilin sa imo the moment you decide that the person will be guilty beyond reasonable doubt, because there's really no absolute truth. It's not absolute truth, but it's your moral truth that is the proof beyond reasonable doubt. So if you think that there is a inch of doubt there, then you need to acquit the person. Okay, so we have two forms of laws of early Filipinos. We have written and unwritten. So written code promulgated by Dato Sumakwil. Remember, this also came out in the board. What's the oldest written code? So that's in 1250 AD. So Sumakwil of Panay, that's Maragtas Code. And Dato Kalanchaw Panay, your Kalanchaw Code in 1433 AD. So how about this? It is the power of the state to enact such laws or regulation in relation to persons and property as to promote public health, moral safety, and general welfare and convenience of the people. They are using this, di ba, to nila now. All persons should be vaccinated by virtue of our police power. Okay? So we have other inherent powers of the state. We have powers of eminent domain and powers of taxation. Inherent powers means it exists even prior to the Constitution. No written laws. In short, even if there's no written laws that provides for this, it can still be enforceable. So these are inherent powers, not provided in the Constitution, not provided in the special laws or any other laws, because there's no need for the law to provide for it, because it's inherent powers. If the state exists, these powers exist. If this does not exist, there's no state. So that's inherent powers. Powers of eminent domain and powers of taxation. For powers of eminent domain, there should be for public purpose, for just compensation, and due process. So eminent domain, they can get your property for just compensation. And just compensation, that's fair market value at the time of at the time of acquiring ownership over your property. Power of taxation. Okay. From the word itself, we know that already, power of taxation. Okay, how about this? When the court has once established a code of law germane to a particular proven facts, it will conform to that standard and applies to every cases in the future. Stare decisis, this is very important. Okay, so if the Supreme Court, for that matter, decided, because we can say that there's a stare decisis in here if it was already, if the case was decided by the Supreme Court. If the case was decided by the Supreme Court and there is any cases of similar nature to that of the case that has been decided, then what has been the decision of the court, okay, can be used to decide this particular case. So that's stare decisis.